If you or someone you love has a past arrest, even something minor, even something that was dismissed, even something that happened years ago, and you are planning to file any immigration application in 2026, you need to watch this entire video before you submit a single form. Because what USCIS and ICE are doing right now is not what it was 2 years ago. The enforcement posture has shifted, the internal guidance has changed, and people who thought they were walking into a routine green card interview are walking out with a notice to appear in immigration court. This is not a drill. This is happening right now across the country to real people who did not know what you are about to learn. Welcome to Immigration Path USA, the channel that gives you the clear, accurate, and honest immigration information you need, especially when the stakes are highest. I am genuinely glad you are here today because this topic is one of the most consequential and least understood issues in the immigration space right now. And the consequences of getting it wrong are not a delayed application or a request for more evidence. The consequence of getting this wrong can be removal from the United States. And before we go one second further, here is my standard but absolutely sincere disclaimer. I am not an attorney. Nothing in this video is legal advice. Everything you're about to hear is for educational and news purposes only, based on publicly available USCIS policy guidance, federal memos, and immigration enforcement data. Your situation is unique, your history is unique, and the intersection of your specific background with current immigration law requires the judgment of a licensed professional. Please consult with a qualified immigration attorney before making any filing decisions. I will say that again before this video ends because it is that important. Now let's get into exactly what is happening and why it matters so much right now. The shift we're talking about starts at the top of the enforcement chain. Under the current administration, both USCIS and ICE have been operating under expanded enforcement priorities that represent a significant departure from the more limited enforcement frameworks of recent years. DHS leadership has issued internal guidance, and in some cases, public-facing policy memos directing USCIS officers to apply heightened scrutiny to applications where the applicant's background raises any question about admissibility or good moral character. That phrase, good moral character, sounds subjective, but in immigration law, it has very specific legal consequences. And understanding it is central to understanding why the risk environment has changed so dramatically in 2026. Let me explain the mechanics of what is actually happening at the form level, because this is where theory becomes reality for people sitting at home trying to decide whether to file. When you apply for adjustment of status, that is the I-485 form, the application that allows someone already in the United States to apply for lawful permanent residence, a green card without having to leave the country, you are not just submitting a form requesting a benefit. You are submitting yourself to a comprehensive background investigation. USCIS runs your biometrics. They check FBI criminal databases. They check Department of Homeland Security databases. They check records you may not even know exist about you. They can and do look at arrest records, court dispositions, charges that were reduced, charges that were dismissed, deferred adjudication agreements, expungements, all of it. And here's the part that shocks people every single time. An expungement under state law does not erase your record for immigration purposes. This is one of the most dangerous misconceptions in the immigrant community. If a state court expunged your record, the state may treat it as if it never happened. But federal immigration law does not recognize state expungements the same way. USCIS sees the underlying conduct. The arrest, the charge, the plea, the disposition, all of it remains visible and relevant to your immigration case, regardless of what the state court did with it afterward. But here's the catch that most people are missing. And this is where the real danger lives in 2026. It is not just that USCIS might deny your application because of a past record. The deeper and far more consequential risk is what USCIS can do after they deny it. Under a policy framework that has been significantly expanded under the current administration, USCIS officers have explicit authority, and in many categories, explicit direction, to issue a notice to appear, which is the document that initiates removal proceedings in immigration court when they deny a case involving an applicant who appears removable. This means that the act of filing your I-485 or your N-400, your naturalization application, can, under the wrong circumstances, be the event that triggers not just a denial, but active deportation proceedings against you. Let me say that clearly because it needs to be understood without any ambiguity. Filing an immigration application when you have an unaddressed issue in your background does not just risk a denial. It can risk your physical presence in the United States. And the difference between those two outcomes, a denial versus a notice to appear, is the difference between trying again later versus standing before an immigration judge and fighting to stay in the country you have built your life in. This is where it gets critical for anyone who has ever had any interaction with law enforcement, no matter how minor it seemed at the time. Let's be specific about what kinds of records create risk, because the range is wider than most people assume. Obviously, serious criminal convictions, felonies, crimes involving moral turpitude, drug offenses, have always created significant immigration bars and risks. But in the current enforcement environment, the concern extends well beyond serious convictions. DUI arrests and convictions, even first offenses, are being scrutinized far more aggressively than in past years. Domestic violence charges, including charges that were dropped or that resulted in a protective order rather than a conviction, can trigger inadmissibility findings and referrals to immigration court. Drug-related arrests, even for minor possession, even in states where the substance has since been legalized, remain federal immigration bars because immigration law operates under federal standards, not state ones. Fraud-related offenses, even misdemeanors, multiple traffic violations in some contexts, and for naturalization specifically, any conduct within the statutory good moral character period, typically the 5 years before your N-400 filing, or 3 years if you are filing based on marriage to a U.S. citizen, gets examined in detail. The N-400 application itself asks direct questions about arrests, citations, and charges. It asks about your affiliations, your tax filing history, your travel history, your marital history. These are not casual questions. They are sworn statements. Providing false information on an immigration application is a federal crime, and USCIS officers in 2026 are cross-referencing the answers on your application against the databases available to them with a level of scrutiny that exceeds what many applicants, and frankly, some attorneys who are not deeply specialized in immigration law, anticipated even a year ago. Let me tell you about a situation that captures exactly how this plays out. And while the names are fictional, the circumstances reflect what is happening in immigration law offices across the country right now. His name is Daniel. He came to the United States from Mexico 17 years ago. He has a wife who is a U.S. citizen. They have 3 children, all born in the United States. Daniel has worked consistently, paid taxes, and built a life in a mid-sized city in the Southwest. 7 years ago, he was arrested after a traffic stop where the officer detected alcohol. He was charged with a DUI, a misdemeanor in his state. He completed a diversion program, paid fines, and the charge was eventually dismissed after he fulfilled all the program requirements. His state record was later expunged. Daniel understandably believed this chapter of his life was closed. 2 years ago, a family friend told him he should finally apply for his green card through his wife. He found a notario, a non-attorney document preparer, who charged him a significant fee and filled out his I-485 and accompanying forms. On the application, the notario advised Daniel that since the charge was dismissed and expunged, he did not need to disclose it. Daniel, trusting this advice, signed the forms, and they were submitted. At his adjustment of status interview, the USCIS officer asked him directly about his arrest history. The officer had the record, the original arrest, the diversion program, the dismissal, in the system. When Daniel said he had no arrests, the officer flagged the discrepancy. The interview was terminated. Shortly after, Daniel received not a request for evidence, but a notice to appear in immigration court, citing both the underlying DUI conduct and the apparent misrepresentation on his application. Daniel, who had a completely viable path to a green card if the case had been handled correctly from the start, is now in removal proceedings, with his wife and 3 American citizen children watching the process unfold. The notario who prepared his application bears no legal responsibility for the outcome. Notarios are not attorneys. They cannot give legal advice, they cannot assess admissibility, and they cannot be held professionally accountable when their guidance leads to catastrophic outcomes like Daniel's. Daniel's story is not rare. It is playing out in city after city, in cases involving people who had every reason to qualify for the benefit they sought, if only the potential issue in their background had been identified and addressed properly before the application was filed. So, what should you do? Here is the 3-step action plan that everyone with any immigration goal and any history, criminal, civil, or otherwise, needs to follow right now. Step 1. Do not file anything until you have had a full consultation with a licensed immigration attorney. Not a notario, not a document preparer, not a family friend who went through the process themselves, not advice from a Facebook group or a YouTube comment section, including this one. A licensed immigration attorney. Before you submit any form, you need a professional who can review your complete history, assess every potential ground of inadmissibility or deportability that applies to your situation, and advise you on whether filing now is safe, whether additional steps are needed first, or whether there is a different strategy that better protects you. The cost of a consultation, even a thorough one, is a fraction of the cost, financial and human, of defending yourself in immigration court. This step is not optional. It is the foundation of everything else. Step 2, gather your complete legal history and be fully transparent with your attorney. Pull your court records from every jurisdiction where you have ever had any legal interaction. Request your FBI identity history summary. This is something any individual can request directly from the FBI, and it shows you exactly what is in the federal criminal database under your name and fingerprints. Seeing that record before your attorney does, or before USCIS does, puts you in a position of knowledge rather than surprise. Bring everything to your attorney consultation: dismissed charges, arrest without conviction, traffic violations that resulted in court appearances, old protective orders, anything. The attorney-client privilege protects everything you share with your attorney. The worst thing you can do is withhold information from the one professional whose job is to help you navigate exactly this situation. Step 3. Protect yourself from the people who will exploit your fear. This enforcement environment has created a population of frightened immigrants who are easy targets for unscrupulous actors. Right now, across social media, in community WhatsApp groups, in front of churches and community centers, there are people claiming they can fix immigration records, guarantee approvals despite criminal history, or provide special access to USCIS processes that legitimate attorneys cannot offer. None of it is real. None of it is legal. And paying for these services does not just waste money. It can introduce additional fraud into your record that makes your situation dramatically worse. If you are ever uncertain whether someone offering immigration help is legitimate, you can verify licensed attorneys through your state bar association's website, and you can find accredited representatives through the Department of Justice's recognition and accreditation roster. Now let's talk about the broader context, because understanding where this enforcement posture comes from and where it is going helps you plan beyond the immediate crisis. The expansion of USCIS enforcement and NTA issuance authority has been a deliberate and structured policy choice under the current administration, built on executive authority that does not require congressional action to implement or to intensify. The legal framework authorizing USCIS to refer denied cases to immigration court has existed for years. What has changed is the direction and frequency with which that authority is being exercised. Courts have not meaningfully constrained this authority, and the current composition of the federal judiciary makes significant judicial rollback of these policies unlikely in the near term. Congress could act to legislate limits on USCIS enforcement referral practices, but in the current political environment, comprehensive immigration legislation that constrains enforcement is not on a realistic timeline. What advocates and immigration attorneys are watching closely are specific federal court cases challenging the procedural fairness of certain NTA practices and the application of the good moral character standard in specific categories of cases. Those cases matter, and their outcomes could shift the risk calculus in specific application categories. But they will not resolve in the next few months, and they will not help someone who files tomorrow without legal guidance. The people navigating this environment, people who came here, built lives, raised families, contributed to their communities, and made one mistake, or simply had one encounter with a legal system that treated them harshly, they deserve to know exactly what they are walking into. They deserve honest information, and they deserve the professional help that gives them the best possible chance of staying in the country they call home. That is why we do this work. And that is why you need to share this video with anyone in your community who is thinking about filing any immigration application right now. The information in this video could change the outcome of their case. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.